Hello and welcome to another episode of Right to Travel Debunked. Today's episode comes courtesy of Charlie Dan, who left the following case in the comments. Quote, "No license is required of the natural individual traveling for business, pleasure, and transportation. Wingfield v. Fielder, 2nd, California, 3D 213, whatever." It turns out Fielder is a popular case among the Right to Travel crowd. In this website, yhvh.name, which is about right to drive without a state license. The case also shows up. It shows up in a number of different right to travel websites and sovereign citizen websites. As you can see here, the quote, "No license is required of the natural individual traveling for personal business, pleasure, and transportation. Wingfield v. Fielder, 2D, California, this is the actual Wingfield v. Fielder. As you can see, it's from the Court of Appeals, California, 3rd Appellate District, December 7th, 1972. It was Harold Wingfield v. Jury W. Fielder, Director, etc. We're just going to keep it short and sweet for this one. Harold Wingfield was an aircraft pilot who has his license revoked, and he was suing to get the revocation reversed as part of the lawsuit. And as you can see here, it looks like he won this stage of the case. I'm not going to look up what it was dealing with. There's some discussion here about there was no substantial evidence to warrant a finding that Wingfield was flying at unsafe altitude or in an unsafe manner. It deals with how low he was flying in order to spray pesticide on crop fields. But just to keep it short and sweet, number one, this has nothing to do with driver's licenses. This is a case about aircraft pilot licenses. Unless you fly an airplane to get to work or for fun, this case really has nothing to do with right to travel. Number two, if we're assuming that the quote cited by right to travel websites is a quote from the case, that quote does not appear in the case. If you look for a natural individual, the quote does not appear anywhere in the decision. If we're going to interpret that natural individual text as a summary of the case, that is not an accurate summary of the case in any way, shape, or form. The case doesn't even say that you can fly an airplane without a license if you're doing it for fun. And in fact, you do need an aircraft pilot license to fly an airplane if you're just flying for fun. So, again, this is a fake quote, as usual, from a real case that has nothing to do with whether or not you need a license to use your car on public highways. Since I've gotten some new guys in the comments section, ask yourself this: if the right to use your car on public roads is a recognized right, why do these guys have to use fake quotes and lie about cases to prove their point? If there was really a court case or Supreme Court case that says that you have the right to use your car on public roads, they would just post it. They would not be using fake quotes and misrepresenting cases to make their point. The fact that they have to lie to prove their point shows that they're wrong, that what they're saying is nonsense.